The Firm, India's only show on corporate law, tax and audit matters.
Hello and welcome to The Firm. It's almost the end of the year, so we're taking a break from the news. No CCI orders, no draft poem guidelines. Instead, we have a slightly different show lined up for you today. 800 years of the Magna Carta, how the rule of law has evolved in India, and why TPP was the buzzword at the Global Congress on Intellectual Property and Public Interest. The Magna Carta turned 800 this year. So as we wind down to the end of the year, we thought it appropriate to celebrate that grand birthday and examine the evolution of the rule of law in India. Aayush Ailawadi rounds it up.
The Magna Carta was sealed in Runnymede, England in the year 1215 as a peace treaty between King John and a group of rebel barons. It established the principle that nobody was above the law, not even the king. Later, the Magna Carta was taken overseas by the British, so many colonies built legal systems based on the Magna Carta. During the American freedom struggle, the Magna Carta was looked at as a symbol of liberty, and its principles were enshrined in the Bill of Rights. These very principles are the basis of most constitutional democracies the world over, including India.
Rule of law, independence of judges, fair trial, due process, justice. This is really what Magna Carta stands for, and it's as relevant today in the very complicated world we have today as it was in 1215.
3,000 years before Christ, the Mahabharata says the same thing. The Upanishads and the Manusmriti and the Arthashastra say the same thing. What is the same thing? It is the supremacy of law, of dharma as we called it, above the sovereign. The most sovereign of all sovereigns is dharma. Non-discrimination, equality, sanction of the law. These are age-old concepts.
Age-old may be, but India still struggles to fulfill them. To put things in context, India ranked 59th on a list of 102 countries worldwide on this year's edition of the Rule of Law Index, recently released by the World Justice Project. And be it judicial independence or judicial overreach, or even delays in justice delivery, India's track record has been dismal on all these counts.
The biggest threat to judicial independence in India were the emergency years of 1975 to 1977. The darkest period in Indian democracy, where the rights of Indian citizens were curtailed by the Indira Gandhi government. The Supreme Court succumbed to executive pressure as well when in the ADM Jabalpur or habeas corpus case, a 5-judge bench of the Apex Court ruled in favour of the state's unrestricted powers of detention. The only dissenting judge, Justice H.R. Khanna, was denied Chief Justiceship. At the time, Supreme Court justices and Chief Justices were selected by the executive. Since the 90s, a collegium of judges has overseen the selection of judges. Parliament's efforts to change that failed, when in October this year, the Supreme Court struck down the NJAC Act as unconstitutional and void.
Sir, what has been the verdict today from the court?
That the amendment has been declared unconstitutional.
The NJAC gave the executive an equal say in judicial appointments.
Would you say that judicial independence is imperative to the rule of law?
Oh, absolutely. Oh, absolutely. It is that basic. In fact, that's the ratio of the judgment in the NJAC case. That it may have stepped out or it may not. I'm not discussing that. I'm only mentioning it, that that's the basis of it. Because you have preponderance of non-judges to appoint judges, which of course they keep saying is not happening anywhere else in the world. Yes, but nowhere else in the world do you have so much of this jockeying for position, getting places in as judgeships, etc., as you do in India. But if you want to preserve the independence of the judiciary as a separate unit of government, I believe there is no other way than to keep it independent. And that's what a man like Justice Venkatachala suggested in his review of the Constitution. He suggested a national commission with 3 judges and 2 non-judges. And that was where the whole split occurred. And that couldn't be passed, and that he said was because of the basic features of the Constitution. He also said that.
It's a fallacy to think that the NGAC will diminish, erode or eliminate judicial independence. It's about structures and forms. I support the NGAC, you may support the collegium. I think the last word has been said for the time being by the judgment.
Well, we moved rather in the other direction. I mean, our system was, until a few years ago, one in which the senior judges were all appointed by a government minister. Now, he did it on advice, he did it with the concurrence of the judges, not their approval, but he would consult the judges, and the appointments were actually fine, and nobody doubted independence. But it did look odd that the executive should be appointing the judges. So we now have a system with an independent appointments commission, and I think that's much better, because it means that everyone in the country can have confidence that the judges who are deciding their cases, deciding if they go to prison, deciding if they win their case or lose their case, deciding whether they win or lose a case against the government, are demonstrably independent. I think that's hugely important.
The Magna Carta may not have envisioned an activist judiciary, but in India, the Supreme Court has a view on virtually everything. 14 years ago, it directed all buses, three-wheelers and taxis in New Delhi to convert to CNG. This week, it ordered a temporary ban on diesel SUVs and luxury cars. From cleaning of temples and fighting the monkey menace to cancellation of telecom and coal block licenses, judicial activism on the part of India's courts has often been construed by lawmakers as judicial overreach.
So do you think that there's a very thin line between limiting government powers and perhaps judicial overreach?
Oh no, I don't believe that. I don't agree with your judicial overreach. There's no judicial overreach. I refuse to accept that. For the simple reason that whatever is done can be criticized if it's wrongly done, of course. But the judges have to, I don't like the word interfere, but the judges have to interpret a particular state of affairs or a particular set of circumstances in accordance with law. As long as they do that, I find nothing, there's no judicial overreach. There would be less interference if the executive did its job.
India differs from the United Kingdom in that your Supreme Court is able to strike down legislation on the ground that it is contrary to the Constitution. That's because you have a written Constitution. We in the United Kingdom have no written Constitution, and the fundamental principle of our unwritten Constitution is that Parliament is supreme, so that if Parliament makes a law, the judges have to apply it. They are not in a position to strike it down on the ground that it's unconstitutional.
Over time, the judiciaries in countries like India, like the UK, the United States have generally found an appropriate balance. Again, I frankly think sometimes our current Supreme Court has been more activist than a lot of past Supreme Courts and has overturned Obama administration regulation and statutes more frequently than has been done in the past by other Supreme Courts. So there are times when the judiciary may move too far in one direction.
Nearly 3 crore cases are pending in Indian courts. The Allahabad High Court is operating at less than 50% of its sanctioned capacity. Perhaps that's the reason that 10 lakh cases are pending before the Allahabad High Court alone. Nearly 40% of the sanctioned posts for judges at India's high courts are lying vacant.
When we hear about the length of time it takes for civil litigation to go through the courts in India, or how long it takes before somebody who has been arrested and charged with an offence is brought to trial, we find this quite horrifying. It seems to me that there are a number of reasons for this quite exorbitant delay in your jurisdiction. One is that you haven't got enough judges. Secondly, I think sometimes the judges are too lenient in granting adjournments when they ought to be strict in insisting that the lawyers bring cases to trial in due time and don't turn up at the last minute saying, "I'm terribly sorry, we're not ready, please can we have another 6 months." There's another difference between your jurisdiction and ours. In the United Kingdom, you cannot appeal at any level without first getting permission. And this screens out time-wasting appeals which are without merit, because there'll be a fairly rapid and short consideration of the application for permission to appeal, where the only issue is there really an arguable ground for appeal or not? And this greatly reduces the pressure on courts of appeal and our Supreme Court.
I don't see why we don't have a system now where we can draw on leading lawyers at the bar, in the High Courts particularly. I've been pleading with Chief Justices of India, law ministers, that request top-ranking counsel in High Courts to please come on the bench, at least for a while. Letter from the Prime Minister that your services are needed, and you will be amazed how much he can deal with and dispose of. Because a man with practice or a woman with practice at the bar is able to dispose of a case in 1/10 of the time of a person who has no practice, who has little practice. And that's where the choice arises. And I hope that the new collegium, etc., will choose well.
While India grapples with more conventional issues, elsewhere in the world the rule of law is facing more contemporary challenges, like privacy and state surveillance in the face of global terror.
One of the first things I had to do when I was Attorney General, I took office just before, 3 months before 9/11, and I watched the planes flying into the Twin Towers. And we had to decide in London what would happen if at that very moment planes were flying towards London landmarks like Canary Wharf, and how would we decide actually to take the planes out of the skies rather than see them land on innocent people. That raises an acute question of the balance between the rights of some and the rights of the many, and the rule of law is the only way you can answer those questions.
When you look at how governments have to deal with issues like climate change, like terrorism, they will succeed better if they work together in a collective form. And there are international law agreements, there are obligations that have been developed over the years through international law, and if they work together within that framework, they're much more likely to succeed than by developing spontaneous emergency responses that may have some short-term success or may not, but over the long term will undermine the rule of law, which is what we're fighting for after all.
800 years on, and we're still fighting the world over to preserve and uphold the rule of law. I guess that speaks volumes about what the Magna Carta stands for even today. In Mumbai, Aayush Ailawadi.
I must give credit to the International Bar Association and its conference on the Magna Carta held in Delhi earlier this month. It gave us a chance to speak to some outstanding jurists. On that note, a quick break, but coming up next, TPP was the buzzword at the Global Congress on Intellectual Property and Public Interest.